Thank you so much, Olas, for that very kind introduction and for this opportunity to sort of take a step back and reflect on broader sort of trends in sort of regulation and competition enforcement in digital markets in India. Because mostly sort of my writing is more specific to particular situations, and I think it's really helpful to sometimes take a step back and look at what's happening overall. And as you mentioned, India is very interesting for a number of different reasons. So what I'll do in, I think, the 45 minutes that I have is to present a brief overview of competition enforcement in Indian digital markets within the context of the broader regulatory scheme in India regarding digital markets, and talk about some of the approaches that the Indian government is taking to overcome some of the challenges that they're facing with regard to regulation of digital markets. And I'll within sort of the broader context, I'll try to focus on a few areas which are sort of more interesting to me vis-a-vis digital markets. So broadly, what the story so far has been that, of course, India is a relatively new competition law jurisdiction, and we've started actively enforcing competition under our new sort of Competition Act 2002 only in 2009. So we're relatively new, and within this sort of period of coming into play, we've also had to deal with digital market issues pretty fast. So far, the only case of active sort of enforcement in India vis-a-vis digital markets, sort of an order where the Competition Commission of India, or the CCI, has actually sort of said that there has been an abuse of dominance in a digital market in India, has been the case of the Google comparison shopping case, which is the Google case of sort of search bias vis-a-vis its comparison shopping services. And that's been the only case. I mean, and even in that situation, the CCI sort of only found abuse of dominance on very, very limited aspects of what Google was doing. A lot of other sort of aspects of Google's conduct was also challenged, but including sort of in ad tech, but the CCI did not find against Google in those sort of things. So that's been the only case, and this has not been for want of sort of cases being brought before the Competition Commission of India. There've been a series of cases brought, especially for, in the markets of cab aggregation and e-commerce, and there are a series of cases brought against Google. And most of these cases, to be fair to the CCI, are still in sort of investigation stage. So a lot of these cases, the CCI hasn't said one way or the other whether whether there's been a violation of competition or not. So they're still investigating. But in a number of cases, they've also dismissed the cases brought against these companies at the stage of preliminary review itself, which is the prima facie stage. And just to go back here and talk a little bit about in the framework of Indian competition law. So the way that the Competition Act is set up in India is really interesting, because anyone can bring what is called an information before the CCI. You don't have to be an aggrieved party or an injured party. And this is also reflected very well in the work of Professor Shilpi Bhattacharya, who talks about sort of how the Indian sort of competition law framework was set up to ensure that the governance of markets predominates over sort of everything else. So the CCI can also obviously suo motu investigate, but it doesn't sort of, anyone can bring a case, and the person bringing the case doesn't have the burden of proving the claim. So the CCI can also independently sort of investigate the claims that are being brought, so as to not overburden parties who are bringing information to the CCI about any kind of violations of the Competition Act. And that's a very to me, that's a very important part of India's competition law framework, which allows for the CCI to get as much information as possible about what's going on in the market and what people think about what's going on in the market, and then investigate that. And the CCI has its an investigative arm called the Director General, the DG, that investigates these the claims that are brought. And so the CCI it's an inquisitorial process where the CCI sort of conducts its own investigation. So when a case is brought, the CCI will make a preliminary opinion about whether this case should be investigated or not. And this is, in my view, maybe just a situation where the CCI looks very, very superficially at the facts and says, okay, is this company even dominant or not? Is it even a competition law case or not? But a lot of cases have been dismissed at this stage itself, which in my view, in some of the situations where the cases were dismissed, it was a bit problematic because the CCI made findings regarding sort of market definition, dominance, etc., that in my view needed sort of further investigation at that stage. So so in my view, the CCI sort of with digital markets did sort of take some quick decisions early on in dismissing cases that maybe they should have investigated further on. And some of these dismissals have, at least on one occasion, has been overturned by the Supreme Court of India. Now, the Supreme Court of India has asked the CCI to reinvestigate that case. So, and in these preliminary opinions, because almost all the jurisprudence that we have so far on digital markets in India is from CCI's preliminary opinions, because like I said, there's only been one sort of significant final judgment, which is on the Google shopping case, the order of the CCI, which is currently on appeal also. But in these preliminary opinions, the CCI has said some interesting things. So for instance, where a company has a significant position in the market, but the CCI has said that it's not dominant and therefore there's no competition law violation. In this case, the CCI has sort of created these terms like significant position in the market, but not dominant in the market, which to me is interesting, because sort of what is the difference between a significant position and sort of dominance? The CCI does not clarify that. And the CCI is being careful to sort of not interfere, even at the, sort of by making any kind of findings at a preliminary review stage in markets that it feels are nascent and growing. So it says these markets need to evolve and we don't want to interfere at all. And in markets where it feels that the barriers to entry are low. But also at the same time, there's been a lack of consistency in the way that the CCI has viewed sort of these concepts in different preliminary orders in different cases. So for instance, in terms of findings of dominance, in the cab aggregation market, where, as I mentioned, there's been a series of cases brought before the CCI, and the CCI has consistently found that cab aggregators are not dominant. So in India, there are two primary cab aggregators. Of course, there's Uber, but we also have a company called Ola. And the CCI has been basically satisfied that there's competition between Uber and Ola, and therefore that neither company sort of has market power in this market. But in some of the early cases that were brought against Ola had a significant market share at that time, sort of upward of 50%. And the CCI did not find that to be dominant on the ground that sort of there were low barriers to entry because Uber was entering this market, and sort of network effects were not so significant. But then subsequently in sort of more recent cases in other markets, the CCI has been satisfied with finding dominance in a market for, say, travel aggregators, where there was a similar market share and similar sort of competition prevalent. There were a number of other players in the market. There was similar sort of entrants coming into the market, but the CCI didn't consider sort of this holistic view of dominance has not considered those holistic view of dominance in those subsequent cases. So we're seeing sort of a shift in how the CCI is sort of even taking these preliminary sort of decisions on which companies are dominant and why. And to me, some of this inconsistency also comes from a lack of a clear normative framework within which the CCI is working. So while we do have a normative framework provided to us within the act, the CCI doesn't really sort of, in its enforcement decisions, actively enforce based on any kind of sort of normative understanding of what competition law should be achieving in these markets. So initially, the CCI essentially was guided by this feeling that these complaints that were being brought against, for instance, the cab aggregators, was by competitors who were unwilling to innovate. They were unwilling to match the technology of these big tech companies, and they just didn't want to compete, and therefore they were bringing these cases. And that seemed to be sort of the reason why the CCI was sort of dismissing these cases at the preliminary review stage itself. And these cases were primarily like predatory pricing cases. There was some sort of hub and spoke collusion cases as well, but primarily abuse of dominance cases in the cab aggregation market. So, but subsequently, sort of more recently, the CCI's view has been shifting, and it's taking an approach where it feels that greater enforcement is required in digital markets. And this might also be based on a few market studies that the CCI has conducted, where it has sort of in e-commerce, telecom, where it has found that sort of there are some competition concerns arising in these digital markets. So, so for instance, in the Google shopping case, where sort of even though the CCI did find abuse of dominance, it was very cautious to say there was balancing sort of the enforcement with sort of any benefits that Google was providing in terms of innovation, and that it didn't want to chill innovation in this market. But more recently, the CCI said that it's imperative that it needs to act swiftly to remove anti-competitive conduct that can harm rivals in winner-takes all markets. So it's taking a more aggressive approach in sort of more recent preliminary review opinions. And another sort of interesting aspect of the shift of the CCI's decision making has been in terms of market definition, where also sort of how it views digital markets is changing with time. And this is seen sort of more starkly, I feel, in the e-commerce cases, where and I'll talk about this in a little bit more detail because I want to focus a little bit on e-commerce. So in India, we have a very, very vibrant and sort of large retail market. And e-commerce is a small part of that. So it was very important in terms of sort of how the CCI would view sort of the Amazons and the Walmart owned Flipkarts in India, to see how it would define the market. And initially the CCI said that online retail and offline retail they were the same market. Online retail was a channel of distribution, was only a channel of distribution, and sort of offline and online constrained each other competitively, and therefore none of these companies like Amazon and Flipkart, as I said, is owned by Walmart, were considered to be dominant because of the way that the market was defined. But that has now changed, and the CCI now views online and offline retail markets separately, and therefore now sort of there is more opportunity for the CCI to find these companies to be dominant, and it is currently investigating e-commerce companies as well. So I'll talk about that in a little bit more detail. But first, I want to talk a little bit about what is really limiting the CCI in terms of its enforcement in digital markets in India. So one of the things has been sort of this big fight between the CCI and other sectoral regulators. Because, and I'll come to this at the end as well, but because there are sort of sectoral regulators in India whose jurisdiction overlaps with the CCI in a number of areas vis-a-vis digital markets, most notably the Telecom Regulatory Authority of India, the TRAI, and sort of this question of regulatory overlap between the CCI and TRAI went up to the Supreme Court of India, and the Supreme Court ruled that when it came to sort of CCI versus TRAI, CCI would have to wait for TRAI to give its view to establish the jurisdictional facts before the CCI could intervene on the competition law aspect of that matter to ensure that there's regulatory conformity. So this has led to this feeling that the CCI has to somehow sort of wait for the sectoral regulator to first give its decision before the CCI can investigate the matter from a competition law perspective. And this has obviously made the CCI more cautious in terms of what it does in matters where there are sectoral regulators involved, especially TRAI. So we see in the preliminary opinion that the CCI gives in the Google Pay case, which is basically a case where the CCI said that there needed to be further investigation into Google's abuse of dominance vis-a-vis sort of the mandatory payment methods that it was imposing on its apps, the pre-installation and prominence given to Google Pay on Android phones. So in that matter, when it came to the issue of data sharing, the issue that was raised by the informants in that case about data sharing between Google Pay and other Google apps, the CCI said that this was a matter that was covered by the Reserve Bank of India, or the RBI, which is the relevant sectoral regulator, and therefore that the CCI would not investigate this matter. So we can see that the CCI is a little bit sort of careful in terms of how it structures its opinions in this matter. And I don't blame the CCI for doing this, because the CCI has been involved in litigation in almost every case in which it has given an opinion in involving big tech companies. So any preliminary opinion, which is actually only considered to be quote unquote an administrative opinion and not a judicial opinion, it's not a finding of guilt, but still sort of big tech companies generally drag the CCI to high courts and invoke jurisdiction of high courts to stall the CCI's investigation into these matters. So this has been a reason for the CCI not to be able to move forward with a lot of the investigations, and why a lot of the investigations are moving very, very slowly in India. And it has become so much that even sort of the courts are saying that this is sort of just a waste of time now, and it's preventing CCI from doing their job. So even the courts are noting that this is becoming just too much of litigation, and it's a lot of it is unnecessary litigation. So that's been one of the things. And then the other thing is that there's talk of a lot of changes in regulation coming up within the Competition Act as well. The Competition Amendment Bill is pending for a couple of years before the Parliament, and the Amendment Bill will not only sort of introduce provisions into the Competition Act that might sort of help the CCI's enforcement of big tech, but also will restructure the CCI a little bit and perhaps make its functioning more effective and more efficient vis-a-vis digital markets as well. And the CCI is also, I think, short of manpower. So all of these factors are making the CCI's functioning a little bit difficult in digital markets. So now I want to talk a little bit about e-commerce, because in India, to me, this is a very interesting sort of part of what might happen to digital markets. So of course, we have big tech players in India. As I mentioned earlier, we have Amazon, we have the Walmart and Flipkart. We also have Indian players like Reliance Jio that are very significant players in e-commerce. But they still occupy a very small position of the retail market, and they see India as a very big growth opportunity because of the large population of India. A large segment of this population is still sort of underserved in terms of internet and the potential to sort of be introduced to e-commerce. And with the prospect of India's population becoming more prosperous in the coming decades, I can understand that for big tech companies, this is a tremendous opportunity for growth. And it might be unlike any other markets where just because of the sheer population of India. So there's definitely sort of a lot of sort of aggressive sort of attempts to woo consumers in India going on. And so these big tech companies have been able to insert themselves as intermediaries in the e-commerce segment in India, primarily through sort of aggressive discounting, these exclusive product launches, giving consumers sort of financing options in terms of buying products, as well as sort of a lot of aggressive marketing that they're doing in India. But it's not been that easy for them because the small retail businesses in India do sort of have a significant sort of lobbying power, and a lot of Indian regulations have been designed with that lobbying power in mind. And I'll come to those regulations in a second. But just to say that sort of when we talk about Indian retail, so obviously this is a very vast market, and as the CCI has in its market definition has generally sort of defined this market in terms of the particular products that are sold. So for instance, smartphones or electronic products or clothing, etc. So so when we also analyze these markets, we probably need to sort of segment them. And for today's talk, I'd like to focus on sort of on smartphones, because there's a case going on currently on smartphones, and also on grocery, because grocery is where sort of the big battle between big tech and these small players is happening. And that's an interesting sort of area to look at. So so we see that with sort of the general sale of electronics or smartphones, etc., the way that the Indian retail markets generally work, for those of you who've not been to India. So in general, you know, in this, even in big cities as well as in smaller towns in India, you'll find sort of a local mom and pop grocery store at every corner of every street. There'll be a local mom and pop grocery store, which stocks almost like all your daily needs. And a lot of people use shop from the local stores. And then in the smaller towns, you will find that there are these, you know, what might be considered like a downtown shopping area, where there's a street that has like a number of small shops, and those small shops sell everything from pharmaceutical products like medicines to electronic items to repair items, etc., etc. So that's a number of small shops selling items side by side. And this is how most of India sort of the retailing works. And these are the small store owners that big tech is trying to really sort of bring into its sort of broader spectrum. So with these kind of aggressive discounting and exclusive launches, what big tech companies have been able to do is to sort of take away market share from these small stores, especially when it comes to electronic products and things like smartphones, because now smartphones are exclusively launched on Amazon, Flipkart, etc. And so these store owners are forced into sort of buying these products from e-commerce companies and then selling them in their stores. And while that may not be problematic in itself, they do face sort of other problems in terms of selling on big tech, which we know in terms of sort of the commissions that they are charged by these companies, the data that is taken from them, the issues with regard to platform neutrality, etc. So there are a number of issues here, and that has led to these small store owners sort of lobbying for regulation that protects them from big tech companies. And when it comes to grocery is an area where uh, um, big tech really wants to be involved, because there is a role for data in terms of sort of, if you can understand what are the regular items that people buy every day, and you can sort of algorithmically determine that, it's easy for big tech to supply these products. So they want to get into this, but this is an area where sort of they are finding it hard to compete with the local mom and pop stores. So what they're trying to do is to collaborate with local mom and pop stores by saying that, look, we will give you some money if you can sort of be a center for us, or we can help you with managing your inventory, etc. So we can find ways of collaboration. But these local mom and pop grocery stores are very, very reluctant, because they don't trust these big tech companies, because they've seen how sort of this data can be used to kind of push them out of the picture completely. So they're reluctant to share data with big tech companies, and the way that big tech companies do business doesn't exactly work with the way that these local stores are doing business. So that's an area where I think big tech is really trying to now come in, and where they're finding some pushback from local stores, and it'll be interesting to see where that goes. So all of this is to say that now we have some laws and regulations other than competition law that kind of governs how competition will take place in retail markets in India. So as I mentioned, that there are like strong retail market lobbies in India, which means that even traditionally, there has been a lot of pushback in terms of what foreign companies can sell or cannot sell through retail markets in India. So for instance, there was a prohibition of foreign direct investment into sort of multi-market, multi-product retail in India. So for instance, a Walmart could not set up like a Walmart store and sell sort of multiple brands in that store in India. So that was not allowed by India's foreign direct investment rules. And then that same those same concepts were then applied through what is called a press note, which is basically a policy statement that the government makes to say that foreign companies, that is companies not based or not having ownership in India, could only be present doing e-commerce in India through what was called the marketplace model, which means that they cannot be buying and selling products in India. They can only be an intermediary and only provide a space for other people to buy and sell products in India. They could not carry any inventory. They did not have power to determine prices on these on their platforms. Entities that were affiliated to these platforms are not allowed to sell on these platforms beyond a certain level. So they're limiting sales by entities affiliated to foreign e-commerce players. And this was because initially they had not made this clear enough, and then sort of Amazon and Flipkart had found ways to get around by setting up sort of affiliated entities who were selling their products and their private label products online on their platform. So now sort of there's a limit on affiliated entities and their ability to sell on a platform in India. And all of this applies only to non-Indian players. So you have the FDI rules that kind of do what competition law should be doing, and say that you cannot price in a certain way. You cannot self-preference, essentially. That's what they're saying, and etc. And then after that, there's been what is called an e-commerce policy that came out in draft form, which was much more extensive in terms of its reach, where the government basically says that any data that these e-commerce companies are collecting has to be stored in India. There's a prohibition in terms of bulk purchases that can be made. There are a number of different things that this e-commerce policy says. You cannot have any kind of discounting of products by foreign e-commerce players. You cannot facilitate lending, the digital financing for products that are sold on these platforms. So this is a draft policy, but it says a lot of things about what especially foreign e-commerce players can do and cannot do. And the government clearly says that we need to create a level playing field between Indian players and foreign players when it comes to e-commerce in India. Now, following this policy, there were certain rules that again came out in draft form, and these were rules that are appended to the Consumer Protection Act. So completely unconnected to the Competition Act, and would be enforced by the Consumer Protection Authority. And they essentially said the same thing that the e-commerce policy said, that you cannot self-preference, that you cannot have what was called flash sales, that you cannot have sort of what was broadly termed as unfair trade practices, that you cannot share data, that you cannot manipulate search results. So they just had a list of things that cannot be done. But again, these are still in draft form. They're very, very broadly worded, and unlikely that they would ever actually sort of become rules in the way that they are worded currently, because they're worded very, very broadly. So likely they will be sort of narrowed down further. But this has also been in play now for a couple of years, and nothing has really happened to bring this to conclusion. So we're just at that stage now where the sort of foreign direct investment rules are limiting what e-commerce companies are doing in India, but they are basically still doing, finding ways to creatively comply with these regulations. And the lack of compliance with these regulations are then determined by the Enforcement Directorate of India, which is a different body altogether. So when the CCI has been trying to enforce against e-commerce companies, the e-commerce companies are saying, but the investigation is now before the Enforcement Directorate, so you wait for them to conclude before conducting the CCI inquiry. But thankfully the courts have said that sort of the competition matter is different, and the CCI has now been allowed to conduct its investigation into Amazon and Flipkart. But it went through a long litigation before that happened. So that's causing a lot of confusion in India, and let's see what happens in terms of where that regulation goes. But the Indian government has found another way to overcome these sort of challenges that it's facing and satisfy its sort of vote base in terms of these lobby groups of retailers in India without having to actually legislate. Can we sort of correct the problems or kind of satisfy the concerns of these retailers in India? And I'll come to that in a second. But before that, just to say that so the CCI is currently investigating a number of e-commerce cases, and most of them, very interestingly, are brought by sort of trade associations. So you have the National Restaurant Association of India that's brought a complaint against restaurant aggregators. Then you have the Federation of Hotels and Restaurant Association of India that's brought a complaint against a travel aggregation platform. And then you have another trade association that's brought a complaint against Flipkart and Amazon. So all these trade associations are being very, very active in terms of pursuing every avenue vis-a-vis big tech, which is very, very interesting to see. And it's also interesting to see how the CCI has kind of found ways around to creatively sort of interpret or move forward with enforcement in these markets. So interestingly, now a lot of these investigations are vis-a-vis sort of vertical agreement issues rather than abuse of dominance issues, because again, these are all markets where there's more than one player involved and both players have significant market positions. So to get over the previous rulings where the CCI said that if there is more than one market player involved, that's significant, then there's no dominance in that market. So so in my opinion, maybe they're going through the vertical agreement route because they don't want to get shot down on the dominance issue. But also the CCI is saying that that these sort of markets where there are like two dominant players, which are all of these markets where currently investigations are going on, the CCI is basically saying that these platforms are offering this similar terms to their say the sellers or the hotels or the restaurants that they're dealing with. They're offering them similar terms. So the players on the supply side of this platform are not getting a better deal. And so so the CCI is saying that basically there's no competition between these platforms to provide better deals to sellers on their platform. So so the CCI is saying that that's a matter of concern. The lack of competition to give better deals to these players is a matter of concern. So they've kind of found a way to get around the dominance issue by saying that we don't see that they're really competing on that side of the market, which earlier they never actually said that, but now they're saying that. So that's also interesting that they're saying that now. So coming back to what I was mentioning earlier, that regulations wise, India is such a mess. Nothing is really happening, but at the same time, a lot is happening, and we're not really going anywhere. So so the Indian government has sort of decided to take a creative route of its own. And so now there is a new competitor for e-commerce players in town, and that's the government of India. So the government of India is setting up its own open platforms. And in e-commerce, it's called the Open Network for Digital Commerce, or ONDC. And the government is saying that we're trying to democratize digital markets by creating our own platforms, which are interoperable, open spaces for everyone to be equal players in. And that's an interesting sort of rhetoric that the government is taking, but it's been pretty successful in the digital payment space. And we know that digital payments is really important for digital markets, because everything in digital markets is ultimately based on payments. So having a competitive payment system is really great. So an Indian government company called the National Payments Corporation of India has set up what is called the Unified Payments Interface, or the UPI. And this came at a time when the Indian government had famously sort of demonetized the currency, and everything was forced to go online. Digital payments were forced to suddenly sort of come up all at once. So UPI was helped by that demonetization move. But basically, this is a system where where consumers can make payments, a variety of different types of payments through a mobile app system. So basically, all you need to do is to create a virtual payment address, and the authentication happens through, again, a government-owned, a government-created digital identification system called Aadhaar, which is problematic in itself. But maybe I won't have time to talk about that. And basically, once you create this and you authenticate yourself, then through this UPI system, you can do a variety of different digital financial transactions, and a number of different features are kind of merged in this platform. You can make payments to merchants, you can transfer money, you can do bill payments, etc., everything. And the focus is on interoperability. So people who have different payment systems can make payments through each other through this interface. And it's really, really convenient and really great. Like, I didn't expect it to be so nice, but having this ability to interoperate and make payments through each other's payment wallets is really great, because then obviously the element of having to have Google Pay or having to have a particular payment wallet completely goes. And that's worked out really, really well in India. And this is regulated by the Reserve Bank of India. And so the Reserve Bank of India has now instituted regulations in terms of sort of what is the limit of market share that any individual payment platform can have on the unified payment interface. And it can also regulate this interface in other ways. So despite sort of this idea of having this open network with interoperability, there were some players that were becoming dominant on this platform, notably Google Pay and Walmart-owned PhonePe were becoming quite popular. So now there's a regulation that says that you have to you can maximum have a 30% share of transactions on this platform and not beyond that. So that has to be complied with, but that's sort of an interesting move by the Reserve Bank of India. So the Reserve Bank of India regulates this, but also regulates where data is stored by sort of these payment platforms, including Google Pay, as I mentioned earlier. So there are regulations that this completely different authority has in terms of how and where data is stored and by these players. So the Indian government basically wants to do something similar with e-commerce. They want to have this platform where buyers and sellers can interact regardless of which e-commerce entity they are on, right? And they want to prevent sort of these regulatory gaps from arising by creating this platform. So through this platform, they're saying that there's going to be no predatory pricing, there's going to be no self-preferencing, there's going to be no sort of using of data in certain ways on this platform. So they're trying to sort of use sort of having this platform and everyone having sort of coming on this platform and transacting on this platform as a way to sort of regulate this market. This hasn't sort of really launched yet. It's, I think, still in a beta stage. So let's see where they go with this, but it's going to be different from the payment system market. So it's not necessary that just because payments were such a success for the government that e-commerce will be an equal success. And interestingly, the rules of engagement on this e-commerce platform are being designed by different stakeholders. So people, you know, the small retail associations, they're all involved in designing how sort of different players can interact on this platform. So that's also interesting. So this is the way that the government is going in terms of regulating digital markets. And I just wanted to share this infographic that I thought was really interesting, because it shows all the different ways in which the different markets in which the government is, the Indian government is trying to create platforms of its own. So there are a number of different markets in which the Indian government is trying to create platforms of its own, including health, utilities, agriculture, general sort of welfare schemes, travel, education. So across the spectrum, they're getting into digital markets and they're trying to create their own platforms, trying to circumvent these big tech companies from having sort of a significant presence by creating their own platforms. And in some areas, they have been pretty successful, including travel and transportation, where they've also been successful. And in health, they might also end up being successful because with COVID, they've had more of a control over what people are doing now. And they have all this data that they collect through the universal ID, Aadhaar, which they connected to the vaccination scheme. So now, and have also, news reports say that they're using that, they've created a health ID connected to Aadhaar through the vaccination scheme, and now they're using that to collect data vis-a-vis health. So that's also interesting that the government is doing that. Sorry, I'm trying to stop share. How do I stop share? Somehow I'm not able to stop share. Okay, so I'm not able to stop share, but anyway. Um, so, uh, so other than that, another interesting area of sort of overlap with the CCI and regulations has been with regard to data protection more generally. So we don't have a data protection law in place yet. Again, I wonder why. But we do have a bill, and the bill has been sort of in Parliament for a while. And I don't, not able to even, somehow it's stuck. I'm not able to change my slides. Is it okay? Um, so the India's sort of draft data bill is based broadly on a consent framework that's similar to the GDPR. But the way that the sort of the enforcement of that is constructed and the powers given to the government vis-a-vis collection of data make this sort of bill very, very problematic. And the CCI has earlier sort of been hesitant to intervene when it comes to privacy and competition. In a previous case, the CCI that was brought with regard to WhatsApp, before the CCI said that sort of there was not enough information before it to make sort of any kind of finding vis-a-vis privacy. But in a more recent preliminary opinion, the CCI has sort of said that that privacy is sort of an issue that is a competition law issue and that it will investigate. And this is vis-a-vis the change in the privacy policy and the terms of use that WhatsApp had. I think it was a couple of years ago, where WhatsApp said that it was going to share data and it changed its privacy policy. And initially it said that sort of if you didn't agree to those terms, then you had to stop using WhatsApp. And then sort of it went back on that and it said that if we're going to give you time to agree to those terms, if you don't want to agree to those terms, there's still going to be time for you to agree. So the CCI sort of investigated that change in WhatsApp's privacy policy from an abuse of dominance perspective, and said in its preliminary finding that this was an abuse of dominance and that it merited further investigation. And it basically said that the way in which WhatsApp had sort of presented this change of privacy policy terms in a take it or leave it manner sort of showed that it was not giving effective choice to consumers, and showed that this was basically an unfair imposition of terms on consumers and therefore an abuse of dominance. And the CCI also went on to say that privacy is a non-price parameter of competition, and that the linking of data across different Facebook products could amount to abusive leveraging by Facebook. So these are all very interesting findings. Also, because I think the CCI can talk about data because there is no sort of direct sectoral regulator doing that in India right now, and because there's no data protection authority in India right now. Otherwise, I feel that the CCI might have been more careful in terms of what it did. So I just want to maybe end by showing sort of this different the different players who are involved with regulation of digital markets in India, and just the enormity of this situation. And I've written enforcement directorate on the side because the enforcement directorate is not mentioned here and also plays an important role in digital markets because of the FDI rules that I was talking about earlier. So as you can see on this chart, on the top, there is the Prime Minister's office, and the Prime Minister's office is the main player that determines policies, laws, and regulations vis-a-vis anything in India. So definitely vis-a-vis digital markets. And then you have the ministry. So you have the Ministry of Finance and the Ministry of Commerce, both of whom have a say. Ministry of Finance more with regard to sort of payment systems, and Ministry of Commerce more with regard to everything else when it comes to digital markets. Then you have a number of different regulators that operate within this sort of structure. So you have the Competition Commission of India, you have the Telecom Regulatory Authority, you have the Reserve Bank of India, and then you have the authority that governs the Universal ID or Aadhaar, which obviously is collecting a lot of data. And the Data Protection Authority, when it comes into place, will also be an important regulator in this market. And then you have a government set up think tanks, specifically one that is called the Niti Aayog, which is sort of planning overall what's happening in the Indian economy, sort of setting the agenda, and sort of some of the stuff that has been coming out from these think tanks is not in agreement with what the ministries are saying. For instance, the Niti Aayog wasn't happy with the way that the draft e-commerce policy came out. So they're not fully in agreement with some of these policies that are coming out. So there's some disagreement even there. And then you have these companies that are now playing an important role, these government companies that are increasingly playing an important role in the digital sphere. And they are also now being regulated by some of these sectoral regulators. Wait and watch to see sort of how that plays out. But we already see with regard to payments that the company that's running sort of the universal payment interface is being regulated by the RBI, and the RBI has a significant power over what this how this payment mechanism is working. So and that doesn't necessarily always meet what other sort of players in the market want to do, like the Ministry of Commerce or even the CCI. So there is like some sort of conflict going on there as well. So there are a lot of different players in India, and there's a lot of different interests that these different sort of government entities have. And it's just interesting to see where this will go. Especially when it comes to e-commerce, where there is a lot of political power on both sides of the spectrum, because both on the side of big tech as well as on the side of the smaller players, and to see how these different regulators are going to end up regulating regulating e-commerce is going to be something really, really interesting. So thank you so much for this opportunity, Oles, and I'm happy to take questions.